Bismillahirrahmanirrahim. My name is Zubair Abbasi, and I had promised that I will make all my lectures publicly available. And here we are with our first session on the historical background of Muslim personal law in South Asia and Pakistan. In this lecture, we will look into different phases and different processes under which Shariat was transformed into Muslim personal law and state law. So when we look into different phases of Muslim family law, we can divide it into four phases. So the first period is the formative period of Islamic law, which is basically Sharia or fiqh. So Quran and Sunnah are the primary sources of Islamic law. Then jurists develop different methodologies such as ijtihad and taqlid to draw principles from the primary sources. And in order to doing this, they use different methodological tools such as qiyas, istihsan, maslaha, darura, saddu zaria, and equity and fairness, these principles, and this list is still developing. For details, we discussed the sources, methodologies, and methodological tools in our course on Islamic jurisprudence. But here we just simply want to mention that Islamic law was formed during first few hundred years of the advent of Islam. And then different schools consolidated into four Sunni schools, two Shia schools, one literalist schools, and one Ibadi, a school that was of Khawarij. We won't go into details of Islamic law, its history, and the history of Islamic jurisprudence in this session. But if you're interested, you can look into any book on the history of Islamic law and jurisprudence for details. In South Asia, Islam came gradually. It was only in 13th century that Muslims established their state in South Asia. And the hallmark of Muslim rule from jurisprudential perspective was the compilation of a legal code that was called Al-Fatawa al-Alamgiriya. That was named after Aurangzeb Alamgir, who appointed a board of scholars to compile this compendium, which was supposed to be used by qadis and muftis. And during the British period, this is where most of scholarly attention has focused, that Sharia was transformed into a state law. First, Sharia became Anglo-Mohammedan law. So Britishers somehow called Muslims Mohammedans, maybe because they themselves were Christians. They were the followers of Christ, hence Christians, and the followers of Mohammedan were called Mohammedans. But we don't exactly know why this term was coined. So why Muslims were not called Muslims or maybe Musulman, this term was also used. But when it comes to legal writing, Muslim law or family law or Sharia or fiqh is called as Mohammedan law. And over the period of time, what happened that British law replaced Muslim law. Different codes were promulgated, specifically after the independence war that was called Ghadar or mutiny by the British, when people in India wanted to get rid of the East India Company. In 1860, Indian Penal Code was promulgated, and then in 1870s and 1880s. So these two decades were very important when civil procedures, criminal procedures, transfer of property law, specific relief act, all these laws were codified. It was also linked with this whole debate with Bentham and his students, James Mill and James Mill's son, J.S. Mill, John Stuart Mill. They were leading. They wanted that English law should be codified so that it should become accessible and predictable. But they could not apply this within England but they could export this idea and experiment with it in their colony that was in India. So Contract Act 1872 was codified. So these laws replaced Sharia. And Sharia was simply confined to the personal affairs such as marriage, dowry, divorce, inheritance of Muslims. So scholarly debates have focused that how Sharia basically met with two paradoxical developments. One, that its sphere of influence was limited to only personal affairs, to family matters, but at the same time, it was enforced as a state law. So previously, Sharia was, or fiqh was in the domain of muftis. So Sharia is described as jurist law because if you want to know what is Sharia or what is Islamic law, you go to muftis, right? Um, uh, I'm not really sure to what extent this is a true depiction of the nature of Islamic law, but this is what the literature tells us. While Halak, Shah, Noel Golson, so they describe Sharia as jurist law, same as Roman law was called jurist law, because who are the oracles of law? Islamic law, these are jurists. Hence, it was jurist, and it was apolitical. State did not interfere it. This is a bit of caricature of history because we don't have actual institutional history of Islamic law. What we know of Islamic law, it is what the law was in books. So our conception of Islamic law with respect to institutional practice, with executive actions such as police and judiciary, qadi courts, we don't have much knowledge about it, unfortunately. And even if lots of new books have been written about Ottoman Empire, about the Middle East, but not much literature is available with respect to the institutional practice of Shariat or fiqh vis-a-vis state institutions. So we know that Aurangzeb Alamgir appointed a board of scholars under the supervision of Sheikh Nizam. And we have Fatawa Alamgiri, that is the best contribution of Indian Muslims to Hanafi fiqh, but we don't actually know that how it was practiced in courts. We have anecdotal evidence here and there, but there is not much of much details are not available. So then after independence, India was divided into two countries, Muslim majority Pakistan and Hindu majority India. And then certain developments happen in independent Pakistan. We will discuss each of these separately. Now, I divide this into different periods. So the first period, when Shariat was transformed into Anglo-Mohammedan law. So what is Anglo-Mohammedan law, which eventually became Muslim personal law? Is it a law which is based on the primary sources of Islamic law, that is Quran and Sunnah? Is it a result of negotiation between colonial and local elites? Is it a modern construction? So what's the nature of Muslim personal law? Is it a product of a political process? And hence, according to Iza Hussein's doctoral thesis, and then she published it in the form of a book, that it was locally specific, intensely political, and richly varied. So these are some of the questions that we will discuss in light of existing literature in this lecture. One thing, or one of the main questions which scholars who have explored the history of Muslim personal law try to answer is transformation of Sharia into state law. So Iza Hussein asks this question, and this is in her words, that why and how did the Sharia, which is an instance-based, judge-centered, and uncodified legal system that aspire to legislate all areas of Muslim life, become codified, state-centered, family and personal law it is now throughout the post-colonial Muslim world? So this is the main question. How did Sharia transform into Muslim personal law? what were the processes, what were the mechanisms, and what are the periods in which this transformation took place. According to Isa, modern state is an undeniable fact. So whatever changes have taken place in the nature of Sharia during its transformation into Muslim personal law is closely linked with the transplant of this notion of state. So here you see that while Bin Halak is lurking in the background, he very controversially argues that Islamic law does not have the concept of state, and which is a very controversial, and I must say that problematic argument, right? That only the West invented the state. The rest simply borrowed it. Very, very Orientalist, very, very Eurocentric argument. And I must say, it does not stand the trial of academic and intellectual evaluation. But this is what it is. So according to Isa, the binaries between public and private, religious and secular, were a result of advent of modern state. So hence, transformation of Sharia from a code which, according to her, tried to legislate. I don't really know what does she mean, legislate, right? Who legislated? God legislated? Jurists legislated? But at least we just know that Sharia tried to provide you or guide each and every aspect of human life. Now, the problem with Western scholars is that when they deal with Sharia, they just translate it as law. And their notion of law is very state-centric. So that's why they just miss the point. They can't actually comprehend Sharia in its own terms. And that creates so many problems. Look into the whole discourse about Taliban. So the whole Western world is afraid of Sharia. So the specter of Sharia is coming. Women would be brutalized as if they provide the paradise to women in their own country. So in their own country, you see that how when it comes to equal payment, females are exploited. When it comes to representation in state institutions, women are exploited. But the whole notion that the specter of Sharia is coming, right, as if it will just take modern world to dark ages. And by the way, dark, their dark, not our dark, not Muslim world's dark. So a lot is basically lost in translation. And I must say that it's not a naive mistake. It's deliberate because it serves power nexuses. Certain narratives are built in order to build certain narratives so that brutal power should be utilized, right? So existing scholarship shows that Muslim personal law was a product of colonial politics. So in Iza Hussein's word, law and its institutions are the product of negotiations amongst elite, both colonial and local. Elites whose motivations were varied and whose strategies and resources are unequal. And this is the main argument in her thesis and then in her book, she says, I argue that codification, organization, and implementation of Muslim personal status required the translation of local and British values and processes, creating a product quite different from some parts, a hybrid law, not a plural law. So according to Isa, Muslim personal law was hybrid. It was a mixture of local and colonial legal principles and processes. And this is very interesting observation that Isa makes. She says, rather than an Arab export, Islamic law, as we know it today, in many post-colonial states may, in fact, be significantly more South Asian in content, structure, and interpretation than previously assumed. Now, the second process, when Anglo-Muhammadan law becomes Muhammadan law and then eventually Muslim personal law. So here, the questions are, what are the transformations brought into the nature of Sharia under colonial rule in India? Why these transformations were brought into effect? Why these transformations? Why not other transformations? What are the implications of these transformations for the application of Sharia in the modern world, both in Muslim majority and Muslim minority countries? So there is a lot of talk about Sharia now after Taliban's takeover of Kabul. So what implications historical narratives have for us to contribute to these debates? Another scholar, and it's one of the best theses that is written about the history of Muslim personal law, and that thesis is about Syed Mahmud, who was the first Muslim judge to be appointed at the High Court. He was the son of Syed Ahmed Khan, as we know it's Sir Syed Ahmed Khan. So in Pakistan, if you say Syed Ahmed Khan, no one actually understand what we are talking about, unless you say Sir Syed Ahmed Khan, as if the Sir was part of his name. Here, the hegemony, colonial hegemony, continues in post-colonial world. So he argues that, just like Izzah, that it wasn't that the British Empire came and they saw and then they conquered and they did whatever they want to do. They could have not undertaken these transformations without the actual consent, participation, and collaboration of local people, local Muslims. Here, this is what he has to say. The British had begun the process of transformation a century earlier, but Mahmud and his contemporary carried the process much further by systematically arranging those branches of Muslim law still in force into a framework compatible with the legal structures instituted by the British for the administration of the law in British India. So locals were basically collaborators. Here is a picture of Sayyid Mahmud, who was a judge. Very interesting story. He was removed as a judge because he was alleged to be alcoholic. Very interesting character. We can talk about him some other time. So here, Alan Gunther continues, and this is very interesting passage from his doctoral thesis that he completed at McGill University. So he says, in the Muslim community, he, Sayyid Mahmud, promoted the replacement of Muslim law with criminal codes and procedural codes and pushed for increased codification in the area of civil law, right? So he was actually promoting these transformations in the name of efficiency, in the name of modernity, whatever you may call it. He vociferously advocated the sweeping away of reliance on English case law as default law where legislation had not specified a law for India. He was asking for codification. He says, in the absence of codification, what English judges are doing, that they are transplanting English law. So that must not happen. By insisting on a legislated code designed for India, he used law as a means of moderating the indiscriminate exercise of power and domination of the British. Now, this is very interesting. So Sayyid Mahmud basically wanted to use modern British law to control the executive discretion. So he was saying, we must codify, we must modernize, because this is the executive which need to be controlled, right? And this is very interesting observation from very famous article by Scott Kugel, Framed, Blamed, and Renamed. He depicts Anglo-Mohammedan law as, in his words, Anglo-Mohammedan law disguises itself as a system. However, it should properly be seen as an interpretative experience that regulates and justifies the raw exercise of power. Very interesting and very provocative argument by Alan Gunther. However, for Fazzi, Asif Ali Fazzi, who has written this famous book, Outline of Mohammedan Law, according to him, he defined Anglo-Mohammedan law as that portion of the law of Islam which is received in India and which is affected both by the changing social conditions prevailing in the country, and by the principle of English law and equity. So for him, just like Isa, it was a mixture. It was hybrid. It was, Isa does not want to use the term pluralistic, but this is what Faizi is saying. How Anglo-Mohammedan law or Muslim personal law was a hybrid, right? So according to Isa, it was a product quite different from the sum of its parts, a hybrid law, not a plural law, right? So when Islamic law and English law interacted with them, the product was completely different from the components it was made up of. And Google seems to carry this idea forward by saying that translation and codification subtly shaped Islamic jurisprudence to fit the needs of a modernizing, centralizing state. It is the needs of this kind of state which ultimately separated Anglo-Mohammedan law from Islamic fiqh or even 18th century English common law. So both according to Isa and Google, Sharia was transformed to meet the needs of rapacious, brutal modern state that the British introduced in South Asia, in India. And another scholar, Goyunchi, makes the argument, carrying the same idea forward, that in India, as elsewhere, it was the colonial administrators and scholars who, driven by various stereotypes as well as by their needs, helped make Islam a rigid, law-centered entity in the lives and minds of colonized people. Right? So the idea was created that Sharia is so fixed, it's so much linked with the religion that it cannot change. It's rigid. That's why it needs to be transformed. It needs to be replaced. It needs to be substituted. You guys need to be modernized. We are not here, East India Company, we are here not to get revenues, not to suck your blood, but we are here to modernize you, to civilize you, same as the Americans were doing in Afghanistan for the past 2 decades. They were civilizing, modernizing, protecting women and minority in Afghanistan. And once those goals have been achieved, off they go, right? And here it's a direct quote from which says that the underlying assumption is that the rigid essential nature of Islamic law invited colonial intervention in order to spark a renaissance under the influence of modernism. So it's a wonderful example of blaming the victim. So why we, East India Company, Britishers are here? Because look at your laws. They're so embedded in religion. They're so anti-women that you need to be modernized. And you know how we will modernize it? We will suck your blood, we will take your resources, and we will modernize you in that process. So you must hail us. We are your saviors. So out of this, what we get? We get that Muslim personal law was a product of modern state. This is very interesting now if you look into the debates about Muslim personal law in India, right? So where these are the Muslims now who try to protect Muslim personal law from the state. And the state in Modi's government has taken a different form. Now, one thing you will notice that these people, they're just talking a lot about modern state, but they don't really tell us what actually state is, right? Who do you mean by state? Is it the executive? Is it combination of different institutions? What do you mean by state? What is it? So state is just like a black box. Everyone talks about it, but no one actually tells us what it is. It's the state. The state is bad. What is state? Is Boris Johnson state? Is Joe Biden state? Is Imran Khan or Pakistan army state? Is Macron state? What is state? What is it? Right? Tell us what is it, so that we should know the beast we are dealing with. But these scholars don't have intellectual courage to ask these questions, to unmask the state, right? So I invite my students to think about it. When you say modern state, what is it? What are you talking about, Who is actually controlling the state? Is it fixed? Does it change? How does it change? What's happening within the state, within this closed box, right? So MPL also had very important role to play in state building. And please don't look into American project of state building in Afghanistan, right? There are so many linkages to Afghanistan, whatever happening in Afghanistan and MPL, that it's amazing. So one of the tragic character that I want to introduce you in this course is called William Hay McNaughton. William Hay McNaughton wrote the first ever textbook on Mohammedan law that eventually became Muslim personal law. It was published in 1825. William Hay McNaughton wasn't an ordinary person. He was born in Calcutta. He knew Bengali, Persian, Arabic, Sanskrit, and he was judge of a court, and he wrote that book that was published in 1825. Very interesting book that it carries the fatwas of muftis. I won't go into details, but why I'm mentioning William Hay McNaughton is that because William Hay McNaughton headed British army which tried to take over Kabul, and everyone was killed except one injured soldier who brought the news that the whole legion has gone. And William Hay McNaughton was also killed by the same pistol that he had given to the governor or the leaders of Afghan the previous day as a gift. Anyway, so Muslim personal law also had this this aspect of state building, right? So this is what Scott Kugel says. He says the British colonial administrators achieved these great changes, transforming Sharia, believing that they were setting South Asian society on the proper path, the path of impersonal government, equal right before the law, public welfare, and profitable business. But perhaps South Asians did not need a modern state, either in its as essential operations or in the way it was imposed. This is how Scott Kugel ends his article. I want to ask Scott Kugel why. Why is it so? Why South Asians did not need a modern state? Only Europeans deserve a modern state? What is modern state? So your wonderful article spreads over many dozens of pages, provides us an interesting rant about transformations which the Britishers brought into Sharia, and the passive Indian Muslims embraced them. They were poor subjects who did not have any agency. But according to you, Scott Kugel, these Indians did not deserve or need a modern state. First of all, what is modern state? And why these poor, impoverished, by the way, impoverished by East India Company, not by themselves. India was one of the richest areas in the world before the rapacious East India Company stepped in. Right? Why they did not need modern state? Why they did not need effective political governance? Right? That Scott Kugel does not tell us. All his article tells is a rant. It's a rhetoric about what actually happened. Now, it's very interesting that how these transformations in the nature of Sharia paved the way for Muslim separatist movement, which eventually led to the partition of India and creation of Pakistan. So what actually happened in 1902, that under Indian Consuls Act, the British introduced separate electorate system in India. Muslims will elect there, Hindus will elect there, Sikhs will elect there, right parties will elect there. So you may call it that it was divide and rule policy, but this is what it was. And how do you identify who's Muslim and who's not Muslim? Lo and behold, whoever is regulated by Muslim personal law is Muslim, and whoever is not regulated by Muslim personal law is not Muslim, right? So how you will vote based on your religion, and how your religion will be determined based on what personal law applies to you. Yeah, this created its separate identity, but we know that there were people, so many people who were just at the edge. Like take example of Khoja Momins and Shia and Maimons. And by the way, no one else other than Jinnah himself was Khoja Shia Muslim. Right? So they lived as Muslims and died as Hindus because their personal law with respect to marriage, divorce, maintenance was Muslim, but they followed Hindu inheritance law. So these people really had to make a choice, whether they are Hindus or they are Muslims, and how that choice has to be exercised based on what law actually governs, regulates your personal affairs. So the people who were just on the boundaries were actually given an option either to choose this or that. And we know that even in Punjab customary laws, these were customary laws which took precedence over Islamic law. So this was actually the British Empire or the colonial politics at that time that make people who are very fluid, their identities were very fluid, to choose either they are Muslims or they are non-Muslims, right? And this whole thing continues. We'll say more about it in Pakistan. So what's the role of Anglo-Mohammedan law in building Muslim nationhood, right? So this is one quote from Anderson's famous article. He says, "It is one of the ironies of British rule that a jurisprudence which first served to implement colonial rule in the 18th century could give form to a part of independent movement of 20th century." He does not actually explain it much, but the point here is that it was the transformation in the nature of Sharia, transformation of fiqh into Muslim personal law that sowed the seeds of separation and independence of Pakistan. Now, how this transformation happened? What were the modes that were used? So the first mode was that British did not know Arabic or even local languages. So what they did, that Captain Charles Hamilton in 1892 translated famous Hanafi textbook Hidayah into English. Hidayah was translated before Fatawa Alamgiri or other books because Hidayah was very concise. It was taught in madrasas, it was very well known. It might not have been a great book for adjudication, but it was very easy for translation, and hence it was translated before Fatawa Alamgiri. In 1850s, Bailey translated parts of Fatawa Alamgiri. Now, Fatawa Alamgiri is much more voluminous, right? And then other books were also translated into English so that British judges could adjudicate without the help of local Muslims. Now, British followed judicial precedents, common law, which is based on judicial precedent. So what happened is that based on the translations, there were so many judgments made, and then those judgments became precedents. And in early 19th century, starting with William Hay Macnaghten's Principles of Mohammedan Law, 1825, these precedents were compiled into handbooks, or whatever you may call them. And then in 1870, Shama Churun compiled another book of precedents, and then Ameer Ali also wrote, Wilson, Tayyibji, Mullah, Faizi, so these books were produced. Now, one thing you see that most of the commentators who compiled these books were Muslims. Even Wilson's book's edition was updated by Abdullah Yusuf Ali. People who have read his translation of Quran know him well. So this is really interesting that this transformation actually took place with the actual participation of Muslims themselves. Certain legislation were also passed in order to complement judicial precedent. They included regulations 1772, which provided that for Muslims, the Sharia or the fiqh would be their personal law. And then in 1913, Musliman Waqf Validating Act was passed. And then Child Marriages Act was passed, and then for Sharia Application Act was passed, so that Muslim women should be given right in inheritance, and then Muslim women's right to dissolution of marriage was also extended in 1939. So that was the story during colonial period. The fourth, and perhaps the most important mechanism of transformation was through education. So if you want to become a lawyer, you have to pass certain courses, and Muslim personal law was one of the courses. Syed Ameer Ali used to teach. Tayyibji was also teacher. Mullah was a teacher at Bombay Law College. Faizi was also a teacher. They were part-time teachers, morning practitioners, and then evening teachers. And that culture somehow has continued in both India and in Pakistan. And even these courses were taught to barristers or the students who wanted to become barristers. So Charles Hamilton's translation of Hidayah was in 3 volumes. Somebody called Grady, who then made it concise into 1 volume, and that was taught to bar students. And this course was also taught to civil servants who wanted to join civil services. So through the process of translation, adjudication, legislation, and education, Sharia was transformed into first Anglo-Muhammadan law. Then when Muslim scholars writing their books, they dropped Anglo, they called it Muhammadan law, and then Muhammadan law become Muslim personal law. What are the main questions that we need to know and keep in mind? One of the key questions is to think about the relationship between Sharia and state law. Is every aspect of Sharia enforceable through the authority of the state? And this is the question which Taliban need to ask themselves. Can you enforce people to pray, to have beards, to perform 5 times prayer, right? And to also do other religious obligations? If you're forcing, can you use the authority of the state for doing this? One. Second is, what's the nature of Sharia? Is it religion or is it law? Why the question has to be either or? It could be both. Certain aspects of Sharia could be related to religion, to faith, and certain to state-enforced law. What's the nature of Sharia in pre-colonial Muslim world? And how Islamic law adopts change with the passage of time? Are there internal mechanisms within Islamic law? And historical and comparative context in which these debates took place. This is the picture of Syed Ameer Ali, who wrote a leading textbook on Muhammadan law, and he kept that updating. He was the first Muslim ever to be appointed on the highest court of appeal in British Empire. Its full name was Judicial Committee of the Privy Council that used to sit here in London. This is Faiz Tayyibji. His book is my favorite. This guy has very sophisticated mind. Like his critique and the way he has compiled, his is the best book, but unfortunately not very popular because it's very difficult to comprehend. What is popular is Mullah's book, or maybe Faiz's book, because they are easy to comprehend. That was a story of a Muslim personal law in British India. Now, what happened when an independent Islamic state came into being? So, one of the first acts that was ever passed that related to application of Shariat. What has happened that Shariat Application Act 1937 did not apply to agricultural land. That was, by the way, Jinnah's master stroke. So Jinnah got that law passed, but there was this exception that it did not apply to agricultural land. Why? Not because of some patriarchy, as feminist scholars would have us believe, but because of the constitutional scheme. So under Government of India Act 1935, land was a provincial subject. And the Shariat Application Act 1937 was a central legislation. So central legislature could not pass an act related to land, only provincial legislatures could pass. So one of the first things that was done after independence was that Punjab's legislature passed this, that now this law also applied to agricultural land. And there was a bit of political context to it, because uh, people who just came from other parts of the India wanted to break the economic backbone of leading politicians who were till the very end part of Unionist Party, which was against Muslim League. So where their vote bank would come from, it would come from their economic muscle. And where their economic muscle is come from, economic muscle come from their land holdings. And if you apply Islamic inheritance law, then the land will disintegrate, right? So that was the main thing that was going on, rather than any ideological affiliation with Islam or religion. Similar acts were passed in Sindh and other parts of Muslim, other parts of and other provinces. One of the most important development that happened was the promulgation of Muslim Family Laws Ordinance 1961, and lo and behold, this year MFLO turned 60, and we have a series of talks on MFLO. We started with Professor Thomas Flishinsky's two-part lecture. He is a Polish scholar and a great social and legal historian. So based on the archives he has described the history of MFLO. We would highly encourage you to listen to that a talk, which is available on Global Institute of Law's YouTube channel. We also had a talk by Professor Werner Minsky on MFLO that is also available on our YouTube channel. And we will have more talks coming in near future. So we are celebrating 60 years of MFLO in Pakistan. And then for procedural, for family courts, we have 1964 Act. Now, MFLO was very, very controversial since the very beginning. Ulama hated it. And Ayub Khan, the military dictator, relied on it to try to legitimize his image as Muslim modernist. So what happens is that there were several attempts were made to repeal MFLO. Right after the establishment of the National Assembly under 1962 Constitution, the very first resolution related to repealing of MFLO. Another attempt was made in 1972, and when Ziaul Haq took power in 1977 and then started this whole process of Islamization of laws, ulama thought that, this is the time to repeal MFLO. But that did not happen. And this is very interesting. In 1980, this is the direct quote from the letter dated 15 January 1980 of the Ministry of Law, which sent this recommendation to Council of Islamic Ideology. And this is amazing. Quote, the Muslim Family Laws Ordinance 1961 is utterly un-Islamic. It is against the Holy Quran and Sunnah. It has dared to amend the Quranic law to the extent of irtidad, apostasy, and its existence is a slur, a blot, a bad blot on the glorious name of Islam and our Islamic country. Such a legislation, or even its name, need not be protected. Let us clean the blot altogether by its total repeal. Actually, repeal did not happen. The Ministry of Religious Affairs also agreed that MFLO was to be repealed, but 2 male and 1 female member of the Council of Islamic Ideology disagreed and proposed that MFLO should be amended rather than repealed in total. So what did Zia did that it amended by repealing 2 sections of MFLO. So section 12 had increased the age of marriage under the Child Marriage Restraint Act to 16 years for females and 18 for males, so that was repealed. And section 13 had declared that second marriage of a husband without the consent of first wife was a ground for dissolution of marriage. That was also repealed. Another change that was important change that was brought during this period was that section 488 of the Code of Criminal Procedure which provided for the maintenance of the wife, was also repealed. And this is exactly the time when Shah Bano controversy had arisen in India in the name of protection of women's rights. But 20 years later, in Al Rakha case, Federal Sharia Court reviewed MFLO and declared most of its sections as valid under Islamic law. Only Section 4 of MFLO and one subsection related to fixing the period of iddat were declared un-Islamic, but an appeal has been pending against this judgment since 2000 before the Shariat bench of the Supreme Court of Pakistan. In Pakistan, there is presumption that the majority of Muslims are Hanafis, so that's why Hanafi fiqh will apply. And with respect to Shias, the majority follows 12-verse Shias, Isna Sharia. That's why Isna Sharia fiqh will apply. This is Supreme Court judgment. These are the leading textbooks of Sunnis and Shias. We have Hidayah and Al-Mudawwana al-Kubra, Kitab al and Minhaj al-Talibin, Al-Mughni for Hanbali. For Shia, we have Shara al-Islam of Muhakkik Hilli. For Ismailis, Daim of Islam. Most of these books have been translated into English. Now, in Pakistan, it's very curious that the constitution defines who is a Muslim and who is not. And Muslim law will only apply to you if you are a Muslim. And if you're non-Muslim, then Muslim personal law will not apply. Here, the question is that if a Muslims belong to different sects or different schools, so which personal law will prevail and why? Say, for instance, it might be what I called a Shia and Sunni couple. So one of the spouse is Shia and the spouse is Sunni. Now, which personal law will apply if they have a legal dispute and why? Colonial courts had developed or formulated two rules. One was that the law of the defendants will prevail. And the second was that in such case, the principles of equity, justice, and good faith will apply. But there were two exceptions to it. One, with respect to inheritance, the law of the propositus, the person who died whose property is to be distributed, that person's law will apply. And the second was that in cases of custody of children, welfare of the child principle will apply. Now, what are the current debates about family law in Pakistan? They relate to the issue of clash of Sharia with modernity. So in the literature, Sharia is depicted as archaic. It's old because it's fixed with religion, but law is modern. It's based with policy research. It's not linked to archaic or fixed texts of religion. So in modern debates, conflict between the principles of Sharia and international human rights law, state law, is depicted as clash between old and the new. Old is Sharia and the new is modern international human rights law. Another debate is about the transformation that has been brought into the nature of Sharia. So is Sharia state law, or is it just a moral code? And if Sharia is fixed, or is it evolving? So what is Sharia? What's the nature of Sharia? Is it fiqh? Can we understand Sharia? Only God knows Sharia, and we can only try to understand it. So our understanding that is fiqh is not fixed. It changes with the change of time, with the change of circumstances, with the change of place. And to what extent Sharia is compatible with international human rights law norms. So international human rights law are modern and secular. Sharia is religious and it is immodern, if I may coin that term, right? And another debate is about the impact of Sharia on political and economic development. So Taimur Quran, who's an economist, has very controversially argued that why Muslims are economically and politically backward because of Sharia, right? very controversial, very Orientalist thesis, but very influential too. So these are some of the main debates. And with this, I want to end today's session. Thank you very much for listening to me. And I hope to see you in our next session and next class.